This is file number 23-01767, FY, council appearance.
Good morning, Your Honor. Angela Delvera on behalf of the people.
Good morning, Your Honor. Dustin Coons for Michael Barron, who's here to my right.
Date set for final pre-trial. I need the necessary witnesses via Zoom.
Yes, Ms. Borman is present. She said she would be.
Was that Randy Borman?
Yes. I appreciate the court allowing her to appear via Zoom.
This matter is scheduled to proceed to jury trial August 27th at 8 o'clock in the morning in person at the court. Are we continuing to trial?
Yes, Your Honor.
Yes, Your Honor.
Any matters we should address all on the record?
Not today, Your Honor.
I'm sorry. August 27th, is that right?
August 27th?
Okay.
Any additional matters for the record?
No, thank you.
No.
Thank you. You're all set for today. Thank you.
Thank you.
Thank you, Ms. Borman. Let's go with that. Record in the matter of the people of the state of Michigan versus Keith Cooper, file number 24-01482. Council appearance.
Good morning, Your Honor. Supreme Court Sally requesting permission to practice under MCR 820 under the supervision of APA Abigail Wilson.
Permission granted.
Jacob Riley on behalf of Mr. Cooper.
The time that was set for final pre-trial, do we have necessary witnesses here?
No, Your Honor, after contacting the witness or the victim in this case 4 times in the past week alone, she has not responded to any voicemails, any calls, or any emails, and she has failed to appear today.
Council, how do you want to proceed?
Defense would request dismissal at this time.
Motion to dismiss is granted without prejudice. The people do have the right to reissue the charge against you if they re-engage with the necessary witness, okay? Do you have any questions? Additional matters for the record, council?
I think for the people, Your Honor.
No, Your Honor.
Okay, so we'll get you a copy of the dismissal in just a moment. Give him a copy. On the record in the matter of the people of the state of Michigan versus Felicia Jackson, file number 23-02951.
That's the issues for people about seeking permission to practice under MCL 8.120 under Abigail Wilson as my supervisor.
Jacob Riley on behalf of Ms. Jackson.
Okay, today was the date and the time that was scheduled for a plea.
Yes, Your Honor. We have paperwork.
Okay, it says here the people are offering for you to plead Ms. Jackson to account of abandonment, cruelty to one animal under MCL 750.504A. Misdemeanor maximum penalty is 93 days and or $1,000. You understand that?
Yeah.
And you want to accept that offer?
I do.
There's also restitution in the amount of $3,637. Who's that owed to?
I am animal control.
Okay, I need a restitution sheet as well. And you're agreeing to that amount of restitution?
Yes, Your Honor.
Okay. Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
You can put your hand down. Okay. An advice of rights and plea information sheet. Is this your signature?
It is.
Did you read this document?
I did.
Okay, and you've gone over these rights with your attorney?
Mhm.
Is that a yes?
Yep.
You understand each of those rights?
Yes.
And you want to give up those rights today in order to accept the offer and plead guilty to abandonment, cruelty to one animal?
Yeah.
Okay, you understand that you have the right to the presumption of innocence. So that means that you're innocent, ma'am, until proven guilty. You have the right to require the prosecution to prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You want to give up that right? You have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question any witness called by the prosecution to testify against you. You can subpoena witnesses to testify on your behalf, or you can waive your silence and testify for yourself. You want to give up each of those rights as well?
Yep.
Is that a yes?
Yes.
Anybody threatening you to get you to give those rights up?
No.
Any promises being made to you in exchange for you pleading to this amended charge?
No.
Are you currently on probation or parole?
No.
You understand that a guilty plea could result in a conviction that may have impact on travel or immigration status you may be seeking. So you may be prohibited from entry into certain areas because of this conviction. You understand that? Like if you wanted to go to Canada, they may
Oh,
deny.
yeah, I'm already a felon, so
Okay.
that's already dead.
And so you also understand that a guilty plea could result in the conviction that you may need to report to your current or future employer.
Okay, yeah.
As to account, amended count one of abandonment, cruelty to one animal, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yeah.
Are you sure?
Yes.
Factual basis.
Ms. Jackson, as of June 3rd, 2023, were you living at 313 West Cedar Chavez Avenue?
Yes, I was.
Is that in the city of Lansing, Ingham County, State of Michigan?
Yeah.
While living at that location, is it true that you had 2 dogs in your care?
I did.
Is it true that those dogs both became injured and that you did not seek veterinary care for those dogs that were injured?
Correct.
Would you agree that this constitutes a failure on your part to provide adequate care for those animals?
Okay.
Thank you, ma'am.
Questions from the prosecution?
Not confused.
Or to satisfy with the factual basis, I'll accept your plea. I find your plea made to be voluntarily and intelligently. Sentencing is September 17th at 9 o'clock in the morning. And when you leave here, you go down one floor to check in with probation so that they can get you prepared for a precinct interview. And you should come to your sentencing prepared to pay some fines and costs, okay? Get you down to probation in just a moment. Any additional matters for today's record?
And from the defense, Your Honor.
I'm approaching with a rest of the information.
Thank you. All set.
Jackson, just have a seat. I'll be with you.
On the record in the matter of the people of the state of Michigan versus Mark Anthony Rosales, file number 23-00857. Appearance for the record.
On behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Mark Rosales.
Have you been in contact with him?
I have left several messages and sent emails. I have had no response.
Oh, it should be true.
Your Honor, the victim has not responded to any of our calls in the past 3 days, even though last week we did have an issue. She did say she hasn't received a subpoena, but in this case, I'm slightly concerned. She hasn't responded to anything last week.
It's noted for the record. I understand your concern may be for safety. Is that where your concern is?
Personally, for me, yes.
Sounds good. Okay, that's noted here on the record because you've had prior communication with her. Information mark's going to be issued. Okay. On the Record in the matter of the people of the state of Michigan versus Ivan Delgado, file number 24-00429, council appearance.
Okay, I'll look on behalf of the people, Your Honor.
Hey, good morning, Your Honor. Dustin Coons for Yvonne Delgado, who's here to my right. He does need an interpreter, and I don't know that we have one.
Spanish.
Yes. His friend is bilingual, but not certified. State Court Administrative Law.
I'm gonna reset it. It says that the interpreter was needed, and he had one for. I don't know why they didn't get an interpreter. We got to have certified interpreters. And I don't think it's certified. New August 28th at 8:30. August 28th at 8:30. Works for you, Mr. King?
I'm sure it does, Your Honor.
Yes.
Yes. I guess as a, I don't think the court can or should proceed without an interpreter, but I noticed in the register of actions, there is a bench warrant in this case. It was issued the day before our appearance, our substitution was filed, and I don't know what it's for.
GPS shut off.
Oh,
I revoked his bond, actually. Is his GPS off?
I know he's still wearing it, Your Honor.
Because it was shut off due to non-payment.
Oh, okay.
Is it on? I'm sorry? It's not blinking?
Yeah, you'll listen to the record. It doesn't appear to be on.
Okay, well, we'll remand him in the, wait a minute. He's being remanded. His GPS, I revoked his bond.
To provide documentation that it is back.
It's not blinking. It's been off. I revoked his bond back in July 11th. It's been off all this time.
It's been on, you've been charging.
You gotta pay for it.
I will, I'll get to the bottom of it, Your Honor.
He gets it back on, and he can be released. He's gotta keep it on. Got a stalking charge.
Okay, thank you, Your Honor.
Thank you.
Take it downstairs.
Sí, sí. Yo te llamo ahorita para tener un impacto. Nomás tenemos que pagar el mismo tiempo.
On the record in the matter of the people of the state of Michigan versus Harold McElrath, file number 22-02081 and 82. Council appearance, please.
Can I look on behalf of the people, Your Honor?
Jacob Riley on behalf of Mr. McElrath.
Okay, we have files, both unlicensed dogs. 2022. How would you see it?
Your Honor, my understanding is that the people are prepared to dismiss this.
Yes, Your Honor, we do plan on dismissing these since defendant does not have the document.
Motion to dismiss is granted. You're all set.
Thank you, ma'am.
You're welcome. On the record in the matter of the people of the state of Michigan versus Sonny McGill, file number 24-018996, council appearance.
Can I on behalf of the people, Your Honor?
Assistant Public Defender John Lee, appearing on behalf of Sonny McGill, who joins us via Zoom, Your Honor.
Okay, Mr. McGill, can you hear us?
Yes, I can.
Very good. Today's the date and time set for a retrial on one count of domestic violence. How are we proceeding?
Your Honor, the prosecution has made an offer. At this time, however, Ms. McGill would like to set the matter for a final pretrial.
What's the offer?
The offer is disorderly jostling with Haida.
Pretrial August 28th. August 20th.
Yes.
So,
Sorry, can you repeat the date? 20 or 28?
that's what I want. Didn't I just give Frank's a 28th date or something?
Yeah. So we do have 28 for,
Yeah, we just gave him a date for 28th.
Michael Barron.
It's the 27th. Or,
and Delgado was August 28 too.
yeah. 28th. I think that's what you said.
Michael Barron, this was already scheduled, so.
Who? 27th, so it should be 27th or the 20th for Coombs.
It's the 27th.
Okay, we need to email him so he knows that. Did we give him a notice?
They didn't have a notice.
For Delgado, we just reset that.
It's August 20th.
20th?
Mhm.
Delgado's August 20th. That's the one that he gave him. Okay. Let's see. That was dismissed. This is August 20th at 8 o'clock in the morning, Ms. McGill. You need to appear in person.
Okay, you said August 20th?
Yes.
Okay.
And then
Jury trial. September 17th.
jury trial is going to be September 17th at 8 o'clock in the morning. You also need to appear in person for that as well, okay?
Yes, I'm sorry, could you repeat that one more time? My stuff's kind of going in and out.
Final pretrial, August 20th, 8 o'clock in the morning.
Okay,
Jury trial, September 17th, 8 o'clock in the morning. Both in person at the court, okay?
okay.
Do you have any questions?
No, I don't.
Additional matters for the record, counsel.
And I think for the people, Your Honor.
Thank you.
Your Honor, in regards to the Seabrook contempt hearing, I believe I have Mr. John Hayes on Zoom. I believe he has another hearing in another county at 10 o'clock. Is he not on? Okay, never mind then.
I'm sorry, excuse me. Am I
Yes.
done or do I stay?
Yes, you're free to go.
Okay,
Thank you. He has another hearing, you said at 10.
Yes,
What, can you find out what time he can be back? Then
I can. I also have not seen my officer, if that makes any difference to the court. But we'll see.
Sounds good. Is Jocelyn Davies here?
And
I don't know what Mr. Black is like. Is it
Right
my
here.
computer? Oh, I can't see back
Let me
there.
check, make sure.
Okay, on the record in the matter of the people of the state of Michigan versus Jocelyn Davies, file number 24-00436.
Abigail Wilson for the people.
Okay, Ms. Davies and Mr. Blackman, this is a sentencing and restitution hearing. Are we having a restitution hearing?
Cassidy Kachukis for the people. I was just out in the hall checking to see if our victim is here. He's not here today. We were able to get in touch with him pretty last minute, so I don't know if he was able to make it. So I believe after talking to Mr. Blackman, I believe we were asking to adjourn the restitution hearing because the victim is working on providing additional restitution information.
I'm confused. The victim was notified to be here?
Yes, I could check the time and date, but I believe it was like very late on Friday. That was the first time we were able to get in touch with him. I have some of his concerns if you want to proceed with sentencing, but I don't have his full statement.
Well, I'm more concerned about the restitution hearing. It's one of your concerns if you haven't told us what the restitution is that's owed.
Yes,
So
Your Honor.
I'll adjourn it if it means it's a he.
Yes, Your Honor.
He can get the restitution to you to discuss with Mr. Blackman. If the restitution hearing is necessary, we'll proceed. How much time? That's the next available date.
30 days works for people. Your Honor.
She has a pretrial on August 6th. I could do it the same day.
I'll be here, yes, that'd be fine.
August 6th at 9. Any additional matters for the record?
I have none here.
Okay, let's start with picture notice. Look in here. And then. You waiting for a court date, ma'am?
It's Miss Brubaker, she's mine, we have a pre-trial schedule.
Oh,
for
I see
10:30.
that at 10:30. You ready?
Yes,
On the record in the matter of the people of the state of Michigan versus Angelina Brubaker, file number 24-01733, counsel appearance.
can I only comment on behalf of the people, Your Honor?
you know, Fred Blackman on behalf of Miss Brubaker.
Said she was in jail.
She just recently.
Oh, okay.
Judge.
Said it's the nicest jail off that I've seen. Oh, Mr. Hughes is coming back in. Okay, today was the date, time set for pretrial, one count of assault on a police officer and domestic violence.
People have provided defense with a offer, and that is a plead guilty to domestic violence with no objection to 769.4A status, as well as for the attempted RNO, we have decided to offer disorderly drunk.
How do you want to proceed, counsel?
I'd like to set up for a final pre-trial again. Judge, actually, what the offer I did receive it from my record is plead guilty to domestic violence, no objection to 76948, or plead guilty to the attempted RNO.
Or not A?
Or,
Okay. Is that your counsel?
Yes.
I'll look there. August 20th at 8 a.m. August 20th at 8 a.m. The final pretrial in person at the court. Pretrial September 17th. September 17th for jury trial, 8 a.m. Do you have any questions from the court today, ma'am?
No.
Any additional matters for the record, counsel?
Heading to the people, Your Honor.
Nothing, Your Honor, thank you.
The picture notice to appear.
Thank you.
Mr. Hayes is here, but you say you didn't have your officer?
I don't believe my officer is here. That is correct.
Okay, so how do you want to proceed?
I'd be asking for an adjournment of the bond violation. I was requesting an adjournment of the final pretrial as well because I have found other bond violations as well as possible forfeiture by wrongdoing that the people may want to proceed under. But I would, leave it to the court's discretion.
Mr. Seabrook.
Seabrook, he's in custody downstairs. Mr. Lee.
Oh, Mr. Lee. Okay, so, Mr. Hayes, the matter that you were subpoenaed on is going to be adjourned, so you're free to go. Thank you.
Thank you, Your Honor.
Thank you, Mr. Hayes. I really appreciate it. Oh, he's gone.
Mr. Lee, what are we doing with Mr. Seabrook on his 25 other cases?
Yes, Your Honor. In regard to the dog licensing cases, Mr. Seabrook's mother was helping him while he was incarcerated to gather documents. However, the list was incomplete that she was able to provide. It's going to require Mr. Seabrook's involvement. The update is that there are 7 dogs that are listed in the citations. 2 of the dogs we have paperwork for. 2 of the other dogs he is in possession of and can get licensed. So we are missing documentation on 3 animals. Mr. Seabrook has assured me that he will be able to make that happen. Him and his partner, the mother of his child, were most actively involved in that. So his mother was helpful, but not entirely able to complete the task.
So these need to be reset too? Okay, well, I'm not gonna bring them up. I'm just gonna reset them. Everything needs to be reset for Seabrook.
Your Honor, I did have a bond request asked to Mr. Seabrook.
Does he have a bond?
Not right now, but it's a condition I'm hoping to instate. On his domestic violence case.
Okay, so you want there to be a bond? Or
No, I'm gonna be requesting a no contact order with his mother.
is his mother a victim?
No, but she may very well be a co-conspirator on some felonies that are potentially being issued.
Okay, we'll bring them up.
Bring them up.
Yes, please. Okay, on the record, in the matters of the people of the state of Michigan versus Carrie Alonzo Seabrook, file numbers 24-01395, 23-0328182, 24-00608, 609, 610, 24-01023, 24-0117879, 8081, 8283, 24-0146567 and 66. Council appearance.
Abigail Wilson for the people.
Assistant Public Defender John Lee on behalf of Carrie Seabrook.
Okay, today was the date and the time that was scheduled for a contempt PA 53 hearing and the final pre-trial. And then there was a pre-trial scheduled for the remaining 15 cases. Are adjourning all of these matters due to some additional potential violations, is my understanding, as well as I think there was an officer witness who didn't appear.
That's correct, Your Honor, yes.
Okay, but we did have JSG and they'll be re-subpoenaed here. And so, Mr. Seabrook, you were remanded by, it's like Judge Flores on this, due to the bond violation. Or a bond violation. Potential tampering with your electronic monitoring device. And the prosecution wanted to address some conditions of his bond and conditions while he's in custody.
That is correct, Your Honor. In reviewing this file, I did have an opportunity to start going through some of Mr. Seabrook's jail calls. There are a number of jail calls between the defendant and his mother, in which his mother is three-way calling in the complaining witness in his domestic violence matter, and in which he is also informing his mother to pass along messages to the complaining witness. A number of these messages include statements not to come to court, to write letters with a different story, stuff that basically amounts to probably forfeiture by wrongdoing and possibly witness interference. And so at this time, I'm requesting that a no contact order be instated with his mother, as she has now made herself a witness to the forfeiture, and it as well may be a co-defendant on the witness interference if the people intend to pursue those charges under an aiding and abetting theory. He shouldn't be able to continue this misconduct with the help of his mother, who may also be a co-conspirator. So I'm requesting a no contact order with his mother in order to stop that.
Your Honor, we understand the prosecution's frustration. This case is one that features two young people who had an incident one day and somebody called the police. They don't want to proceed with this prosecution. They want to reconcile. They have an 11-year-old child. And Mr. Seabrook wants nothing more than to get back out into the world so he can begin working again, providing for his partner and his child. We understand that there are allegations of bond violations. We asked the court to consider that these are allegations, and some of this is the first I'm hearing. Multiple phone calls and stuff. I've never heard that before until just now. So we would ask the court to consider some sort of a bond, 10% bond of some sort, and allow Mr. Seabrook to continue to enjoy the presumption of innocence until such time as he's asked to appear again, which he is committed to do.
Put him on GPS tether for the safety and security of the alleged victim. But there's been multiple allegations. I mean, a lot of allegations of tampering with the device. And now there's allegations of violations of my no contact order. So he couldn't have contact directly or indirectly with Kelly Hooks. I I told him that while Kelly Hooks was sitting in the courtroom, because they walked in court together when there was a warrant that they were not aware of, that I needed to arraign him on. He was very well versed on the conditions of his bond. And so I don't care if it's an incident that involved two young people that have a child and they just want to be together. If the court orders you to not have contact during the pendency of a matter for the protection of the alleged victim, and also really to protect you from any further violations, then you're supposed to follow those orders. And to blatantly disregard, if that's the case, the court's order by calling your mom or having your mom make a call on a recorded line, which advises you when you call that this is a recorded line, makes me believe you think you're smarter than the system. Because it told you that the line was recorded, but you still did it anyways. Because you thought maybe the prosecutor wasn't going to listen. I don't know if you are aware, the Ingham County Prosecutor's Office listens to the calls. You're not smarter than the system. And so you could be facing additional charges, additional felony charges. Your mom could be facing charges because you put her in a position to do that, if what the prosecutor's office is saying is accurate. So the prosecutor will provide your attorney with whatever information or evidence is necessary, because those are additional violations that need to be flushed out. I'm not going to disregard that. I recognize there's a presumption of innocence, but when a prosecutor comes to the court and says that they listened with their own ears to phone calls, your jail conversations, that's an overwhelming presumption that there's a violation. And so I have to take into consideration those allegations. So your matter will be rescheduled for a hearing on these violations, as well as the previous violations of you tampering with your GPS monitoring system. While in custody of the Ingham County Jail, I am going to suspend his jail calls unless it's to his attorney. Not to have any contact directly or indirectly with Kelly Hooks. Indirect contact would mean having someone else call her for you, or telling someone to give a message on your behalf. That would be indirect contact. Do you understand that? I'm sorry, I can't hear you. Okay. But he was remanded for this purpose. I think he originally had a 500 personal recognizance bond. And then it looks like I had to see him again in June, and he got a bond of 5,000, 10%. And then now we're here with multiple allegations of bond violations. I don't know that he's someone that follows court orders at this point. That's a presumption that in conclusion, I'm coming to based off of the history so far in this case for the last 2 months, and how many bond violations we now need to flush through in a 2-month period. Also navigating 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. I was pretty good with my count. 15 other cases. In addition to the domestic violence, which is the 16th case, and who knows what we'll have by the time we get back here. So he'll be remanded until the time that we have a hearing on the bond violations.
August 20th.
At 8 p.m. August 20th at 8 a.m. Have any questions today, Mr. Seabrook?
The previous to the violation of,
Can you speak up for me?
the previous to the violation, I was at my job, so I thought I had permission to be at work. And,
You was at work at 3, 4 in the morning?
no, I was at my job, so I wasn't working, but I wasn't.
So we're admitting to the bond violation here. Is that what's happening?
I was trying to.
I asked you, was there a question?
Uh,
That's what I wanted to know. But if you want to make an admission on the record, that's your right as well.
I was asking about,
You were asking what?
I was asked if I could have it bond so I could go back to work.
Did you just hear? So you thought that was a negotiation? Thank you. You're all set. Sorry. He said he was gonna say. Mrs. Swain did not appear. Okay, on the record in the matter, the people of the state of Michigan versus Anthony Devon Price, file number 23-03212, counsel appearance.
Can I almost on behalf of the people, Your Honor?
Jacob Riley on behalf of Mr. Price.
Okay, wait a minute now, what's happening? Mr. Price, you have a sentencing bill. It looks like you got some warrants here. You owe us some money. It was $96 on an improper parking. Yes. In 2021. You're paying today? You're supposed to pay $40 back on November 7th, 2023, and then 30 days later pay the balance. That's what you told Magistrate Milmore. Then you didn't do either. I'm sorry? How much are you paying today? Okay. Okay, so looks like. I'll reset your sentencing because you had an appointment trying to gain some employment. So you were on disability due to some health. Because you complete anger management within 60 days and bring proof of searching for employment. What do you have for us? I don't see anything in your hand. So that's not positive.
It's trying to find a job, but it's been hard. Nobody trying to pretty much hire me if I'm on that.
Nobody's trying to hire you because you're in dialysis, you said?
But,
Okay, and so what about the other requirements I gave you?
the anger management, I thought that it's done type stuff.
I'm sorry, what more done? We had a whole jury trial. What more can we do?
Well, you said sentencing, I thought the case was done both. I guess, I don't know.
I saw you on May 21st. I told you that you had 60 days to complete anger management and set this out 60 days.
I just. Right.
You think something's funny? Counsel, what are you suggesting I do with your client? Because I think he needs to go to jail.
Your Honor, I can report that very recently, Mr. Price has sort of stabilized his housing situation. He was essentially almost the last time we went forward. So I think he's sort of getting his feet under him, getting things in order, but certainly he needs to be more diligent about.
He's laughing. He thinks this is funny.
I don't think that.
That's all I have to vote for you.
What's so funny?
I apologize.
Excuse me?
I don't think nothing's funny. I apologize.
I tried to sympathize and empathize with you under the circumstances. Again, you had an entire jury trial that you were found guilty on, and I tried to have some understanding of the circumstances or that brought you into the position that you look at me when I'm talking to you. I tried to have some understanding about your circumstances and what brought you into the court. And what you took the stand and waived your right to silence and indicated that you were trying to protect your children. So I tried to take that into consideration in my sentencing. I also try to take into consideration, look at me when I'm talking to you, that you indicated to the court that you were having some hard times and that you were also dealing with some medical situations. I've tried to do that, but to come into my court today and not have done absolutely anything you said you was going to do, not even pay the money you were supposed to pay almost a year ago for something that happened in 2021, and then think that you're going to laugh and smirk and make a mockery of this court, to me is inexcusable. So you're being remanded to the custody of the Ingham County Jail. You'll serve 14 days in the Ingham County Jail.
Your Honor, the victim on this matter is requesting restitution. I'm not sure if Mr. Price is contesting the amount.
Restitution for the assault and battery?
That's correct. She has a $456 hospital bill from the assault battery.
We have received the scan of that hospital bill. We do not dispute that.
Okay.
I can get a restitution sheet prepared. Your Honor.
sheet done?
Yeah, I filled out.
Also, Your Honor, we would like to ask if the court has received the victim's impact statement.
I received the victim's impact statement.
Yes, she did provide a statement to the probation officer. Do you have a copy of that as well if you'd like it?
No, there is not one, and this was prepared back in May. We don't have a victim impact statement.
This is what we have as well.
Okay, it says here, victim impact statement. Anthony Price assaulted me, made it where I have to look over my shoulder everywhere I go to the point I want to go get my permit to carry. After the assault, his kids, his baby mama, including him, harassed me until he got put on GPS tether. When I had to watch this man in court lie through his teeth to paint me being the one that assaulted him. After going through so much with this man and his family living above me, torturing me and my son and the neighbor below me, to the point our kids couldn't go outside because his kids would bully ours, or his friends would try to intimidate me. I cannot find the bill at this moment, but it's over $400 for that hospital bill that night. And then the court does have a hospital bill from the date of the incident for the alleged, or for the victim, and the amount of $456, which is not being contested.
That's correct, Your Honor.
Can I get a request?
Okay, so 14 days Ingham County Jail restitution is owed to,
Deontay Kennebrew.
yes, please. Thank you. Restitution is going to be owed in the amount of $456 to Deontay Kennebrew. There's a $75 crime victim rights fee that must be assessed per statute, and now a $50 state minimum cost. $581. We'll make a payment of $50 per month. Your first payment is going to be due August 30th. You have any questions?
I need to make a phone call.
I don't deal with phone calls.
Yeah, if I have my baby.
I don't deal with phone calls in jail. That's not my responsibility. Deal with that in jail. There's the victim statement. Yes, sir.
Basically blocked, which is why. Blocked it.
Cellular data.
Yeah, I'm gonna check on that, because I think when it was blocked, it wasn't blocked at cellular too. I'm trying to figure out why Wi-Fi and cellular isn't connected.
Okay.
Give me
No
10
problem.
minutes.
Thank you.
You don't know his charge. You need his charge.
I put it on.
Except for Marion Smith, except for PA 53. Is Marion Smith set for PA 53 today? Why is he on Zoom?
Mr. Johnson, this is attorney.
He needs to be in person for PA 53. It's a bond violation. He appears today or I'm revoking his bond. He appeared late last time. He needs to appear today or his bond's getting revoked.
Hello?
Hello?
Okay, how,
The notice definitely says in person, so. Okay, we had someone who's just, okay, Mr. Walton. Okay, on the record in the matter, the people of the state of Michigan versus Jonathan Walton have J 0351138 council appearance.
Abigail Wilson for the people.
And Mr. Walton is present in the courtroom. You do not have attorney, correct, Mr. Walton? Let me just find out. Okay, today was the date set for a hearing on a motion to set aside conviction. This is a conviction from 2003 for domestic violence. Okay, I was gonna say I don't see a letter from the AG, but it is. A letter from the Office of the Attorney General, so it's given the information currently in possession of the Attorney General office. The review of Mr. Walton's application in history, criminal history report shows he may be eligible for this conviction under Michigan Compiled Law 780.621. So they otherwise have no objection. Is the prosecution's office taking a position? Yes.
Your Honor, at this time, I don't appear to have the application, and this case is so old, it's not in our system. So I've not had an opportunity to reach out to the victim on this matter. It is rather old. If the Attorney General is saying that Mr. Walton is eligible legally, I have no reason to doubt that. My only concern is the compliance with the Crime Victim Rights Act.
Let's see. I do have information in the court record that would indicate that they did, that he complied.
Okay.
That he served, it was properly served.
Okay.
On your office. And so. And typically it's the AG's that's a little late with getting the information to the court as it relates to whether or not they believe there should be an objection, but they did not. So are you asking for an adjournment so that you can attempt to make contact?
If our office was served and we didn't have an opportunity, I guess that's on us. I leave it to the court's discretion.
So, Mr. Walton, tell me what you've been doing since the time of this conviction.
Studying about life.
How have you been studying about life?
Staying out the way, stand for myself. Research.
It's 21 years. I hope you've been doing more than just staying to yourself and learning about life. What have you been doing? You work? Where do you work?
The car wash.
How long have you been working there?
4 years.
For 4 years. What were you doing prior to that?
Very long.
You weren't doing anything else? You said you've been learning about life. Have you gone to school?
Went to school, LCC.
Okay, so that's what we want to hear. I've been in school, Your Honor. I've been working. Do you have anything else that you've been doing? I'm trying to see, oh, there it is. I don't see any other violent convictions on your record, and the only thing I see after this. I see one conviction after this, it was maybe 2 years after that, so it's from 2005. And so. Based on the information before the court and the circumstances, I think that your behavior warrants setting aside the conviction, as I find the application to be consistent with the public welfare, so I will grant it and date it for today. Do you have any questions for the court today? So you're all set. Thank you. Elias Kristen present? Alias? Okay, who's his attorney? Okay, on the record in the matter of the people of the state of Michigan versus Alias Griffin, file number 23-02809.
You just go deeply on it.
Assistant Public Defender John Lee on behalf of Alois Griffin. Alias? Alias Griffin.
Okay. It's the date and time that's scheduled for a pre-trial, Mr. Griffin, for domestic violence. How are we proceeding, counsel?
People have extended an offer and have been informed that Mr. Griffin believes he has an alibi at the time, but we have not received evidence of that as of yet. And therefore, we assume this needs to be set for a final pre-trial.
Yes, Your Honor, we'd like to set the matter for a final pretrial, and we will forward any proofs that we have in our possession to the prosecutor between now and then.
What's the offer?
Offer at this time is playing to the charge with a recommendation for no upfront jail.
August 28th.
The final pretrial at 8 a.m. Jury trial September 24th.
August 20th, 8 o'clock in the morning, in person, is going to be your final pretrial. Jury trial is gonna be September 24th at 8 a.m., also in person at the court. Let me get you a notice to appear. I just told you your dates. So you won't be able to use the excuse that you didn't know you had court, okay? Do you have any questions? Any additional matters for the rest of the council?
Not the people, Your Honor.
Nothing for the defense, Your Honor.
Thank you. Hillary Hinton here.
She was on Zoom in Buchanan.
On your trip. It's early.
I think Judge was asking if she is here.
Oh, I have not seen it yet.
It's early. Isaiah Williams is here. On the record, in the matter of the people of the state of Michigan versus Isaiah Williams, file number 24-01944, council appearance.
And I'll look on behalf of the people, Your Honor.
Jacob Riley on behalf of Mr. Williams.
Ms. Williams, you can hear us, correct?
Yes.
Very good. Today's the date and the time that's scheduled for a pre-trial on the domestic violence. Was there an offer on this?
Yes, Your Honor, we provided the defense with an offer, pleading guilty to domestic violence with no objection to 769.4A, as well as restitution for the damages suffered by the victim.
Discussing that with my client, he's not interested in accepting any offers at this time. We request a final pretrial conference.
August 20th at 8 a.m. the final pretrial. And September 17th for the jury trial.
Final pretrial, August 20th, 8 o'clock in the morning, in person at the court. Jury trial, September 17th, 8 a.m. in person at the court. Do you have any questions today, Mr. Williams?
Will they mail the papers to me so I can remember the dates? Because I got a lot going on with my kids and stuff, so I'll be forgetting a lot of stuff because I got a lot of things I got to do with my daughter and things like that.
That sounds wonderful. We just told you your date. There's supposed to be something mailed, but mail get intercepted often. And so what could be
So you said that.
What could be unfortunate is if you don't take measures right now while you're on this Zoom to secure that date on the calendar, and then you don't get your mail, and then you miss court, and then you end up in jail on a warrant because you missed court, because that could really be bad for your daughter if you're not available because you're.
So you said August what, and what was the dates again? So I can write it down.
August 20th, 8 o'clock in the morning, in person. And then September 17th, 8 o'clock in the morning, in person.
Okay.
Do you have any other questions?
And what's the address for that courthouse?
We're in City Hall, 124 West Michigan Ave. We're on the 6th floor.
All right. Thank you.
You're welcome. Any additional matters for the record, counsel?
I think for the people, Your Honor.
No, Your Honor.
Thank you. Ms. Hinton is here. Does she have an attorney?
Yes. No, I have no attorney present.
Okay, the prosecutor will log in to meet with you.
I need to.
So sorry to interrupt. Use the restroom. Oh, no.
On the record in the matter of the people of the state of Michigan versus Hillary Henson, file number is 24-01608, council appoints.
Trustee Cheeks for the people.
Okay, Ms. Henson is present via Zoom. And let's see,
Good morning.
good morning. Today was the date that was scheduled for a pretrial on unlicensed dog. How are we proceeding on this?
Yes, Your Honor. Ms. Henson has told me that she does have her license corrected, and if we, as long as we have not yet received a copy of that, she's not able to get it at this moment because she is currently out of town and is at her house. She's going to provide it to her office as soon as possible. So we are asking for either an adjournment or to be set for final pretrial to give us time to receive those items, and then we would like to dismiss off the record once we receive those, if that's okay with you.
August 20th at 10.
August 20th at 10. You have any questions for the court today, ma'am?
No, ma'am.
Any additional matters for the record, counsel?
Not for the people.
You're all set, ma'am.
Thank you very much. You guys have a great day.
You too.
I may leave the call now.
Yes, ma'am. the record, in the matter of the people of the state of Michigan. Have you seen Tanya Tripp? Okay, versus Tanya Joe Tripp, file number 23-03087, 03089, and 24-01961. Council appearance.
Jacob Riley representing Ms. Tripp on cases 23-03087 SN and 23-03089 SN.
Assistant Public Defender John Lee appearing on behalf of Tanya Joe Tripp for case number 24-01961.
Okay, today's date and time set for a pretrial. I have a dog license vaccination, a dog at large, and then one assault and battery. How are we proceeding on these?
Offer has been made, Your Honor. I believe dog tickets, it is, for compliance for dismissal. I have not received that yet. And I'm pulling up the offer for the other right now.
With regard to the dog cases, Your Honor, Ms. Tripp tells me that she can provide compliance in there. So maybe that's something for another.
And the offer in the other case is to plead guilty to assault and battery with a recommendation for no upfront jail and a recommendation for substance abuse assessment and corresponding treatment alongside anger management.
Okay, we could change the date, and I'm assuming you want final pretrial?
We do August 20th for the final pretrial and the pretrial.
Final pretrials, August 20th, 8 AM in person at the court. That's also the date for the pretrial. The dog at large and the dog vaccination. Trial
September 24th at 8.
will be September 24th at 8 AM. Do you have any questions for the court today, ma'am? No, okay, we'll get you a copy of your notice to appear. Any additional matters for the record, counsel?
Briefly, Your Honor, for the AMD file, just so we're being in full disclosure, the victim did tell me that she does have a video that she has not uploaded yet. She will be doing that soon. I just wanted to make sure that I have informed defense counsel of this. I just wanted to make sure that you were aware as well, and that it was on the record that we are still trying to get that video.
Thank you. Any additional matters for the record? On the record, in the matter of the people of the state of Michigan versus Marion Smith, file number is 24-00883, counsel appearance.
You know, almost done on behalf of the chief.
Good morning, man. Please, this honorable court, Kareem Johnson, for behalf of Mr. Smith.
Mr. Smith is present in the courtroom. Today was the date and time set for a hearing on a bond violation, and I think there's a pre-trial for a child abuse court. Are you ready to proceed on the bond violation?
Yes, Your Honor.
Yes.
And I've explained to my client his right to hearing a contested bond violation. Explained to him the nature of the bond violation. I believe he is willing to waive his right to hearing and admit that he had contact with minor child will be a bond to not proceed.
Is that correct, sir? Please raise your right hand. Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
Thank you. Okay, attorney indicated he's advised you of your right to have a contested hearing on the bond violation, correct? Okay, you want to waive that and plead guilty to the violation?
Yes.
Anybody threatening you to get you to do that?
No.
Any promises being made to you if you plead to the violation?
No.
As to the violation that you violated your, as to the allegation that you violated your bond conditions by having contact with the protected person, Sky Marie Smith, without a supervising adult, how do you plead? Have factual basis, mentioned.
Smith, are you on bond to the 54A District Court? See the bond condition, which we're not supposed to have contact with Mrs. Smith without supervising adult. Have Mrs. Smith in your care without supervising adult. Yeah.
Any questions from the prosecution?
I think that'd be fair, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea remains freely, voluntarily, and intelligently.
And then address the court Friday.
Yes, you may.
You know, we are here because the government said Mr. Smith didn't come get his child when the person who has legal and physical custody of the child didn't want the child anymore. That's why we're here. He was out, he was working, he was door dashing. He got a call from the adult that the government gave the child to watch the child, who said, I don't want your kid anymore. Come get your child immediately. He went and got his child while he was out door dashing, got pulled over, and is now back in court with his freedom in peril for taking possession of his child that was not in his care or custody by government order. Is a person who was supposed to be caring for that child by government order said, I don't want to do it anymore. But that person's nowhere to be found. I think this man, the government has to decide whether they want this man to be a father or not. What else was he supposed to do on that day? I know surely if, as a parent, if I got a call from my daughter's school right now and said, Mr. Johnson, you got to come get your kid. We're not going to watch him anymore. I have to go get my kid. He meant this court no disrespect. He was trying to do the right thing as a father. I'd ask the court to sentence him to time served for the violation. He was arrested. I believe spent the 3 days in jail. I think that is sufficient.
How did he end up getting pulled over in the first place? Just
It was an accusation that he ran a red light while he was trying to beat a red light while he was before that traffic stop.
okay, and then he got pulled over and had the minor in the vehicle with it.
Your Honor, based
Yes.
on the details, it was failure to use a turn signal at 3-lane changes.
Okay. And you're saying that he was coming from picking up the child or door dashing?
He was door dashing.
Okay, so how did the child end up in his care if he was out door dashing?
He got contacted from CPS to come get the child.
CPS contacted you to come get the child?
He had the child because the person, his sister, who had the child.
His sister had the child and didn't want the child in her care anymore, so called him, he went to go get the child? Is that what my understanding?
Essentially, yes, yeah.
Okay, and he knew that there was a court order that required him to not have unsupervised contact with the child?
That's part of the problem, but also there's a CPS case in which he was getting the child on that date and time. So there was conflicting.
There was a
situations
CPS
going
case where he was supposed to have visitation with the child that day? Was it supervised?
It's my understanding CPS is going to give you custody of your child, right? CPS is going to give him custody of the child. He has this court order in which he cannot be around the child without a supervising adult. But it's my understanding that that is not what CPS is telling. When we talked to him on that day, is that correct, sir?
Yes, that's correct.
Is that correct?
Your Honor, I do not have the CPS order that is allegedly giving Mr. Abigail Wilson for the people. I apologize. I don't have that order. I don't know what authority. I believe CPS can place a child with someone. I don't think CPS has the authority to grant somebody custody. That's a court determination under the family court. It's my understanding that this occurred the day after he was arraigned and notified of his bond conditions. So I don't think CPS was aware of his bond conditions, but he definitely was. It's not on CPS to know his bond conditions, it's on Mr. Smith. And while I understand there's conflicting information going on here, I don't think, yelling at the government and saying that we screwed up here is appropriate when he was put on notice. I understand there was confusion. I'm going to leave the sentence ultimately to the court's discretion, but I think that's inappropriate.
Well,
Yeah, it's not
I'm trying to understand what the confusion, I think confusion is something that needs to be fleshed out. Did CPS tell him he's supposed to have the child in his care? Is what I want to know.
Not to my knowledge, Your Honor, but I don't have that information. This is all coming from Mr. Smith at this point.
Yeah, because this is not the family court here. So if there's an order from the family court, including a CPS order, our court tends to follow it. So if CPS said the child could be in his custody, all we needed to know was CPS said that we can amend his bond condition. But we don't have anything that tells us that. You're saying that there's something that says that? Who has it?
CPS, I don't know.
How did you notify? How were you notified that there was such an order from CPS?
I had Zoom meetings with them.
Okay,
There's court cases with them, so it's all around to them.
agreed.
And this is all the executive branch of the government, the prosecutor's office and CPS.
Your Honor, if I may, it appears based on the report, somebody did provide the jail with some CPS records that gave whatever custody they were granting on 4/11 of 24. Mr. Smith was arraigned, I believe, on 4/10. So this is very close in time. CPS might have not been aware of the fact that there was this order coming from the court. And obviously when he was arraigned, if this order came after the arraignment, the court doesn't have it either.
Okay, so got it. So there was an order from April 11th
Yes, that's my
for him to
understanding.
have CPS in his custody, but the bond violation happened after that. He would already have been aware of that. Did CPS rescind that order?
I do not know.
Okay. Because this is a very unfortunate case, even the underlying facts. Very unfortunate, because at the end of the day, the person who's suffering is the child. Because both parents have been charged in this particular case. And I think the other parent I already have on. I think, do we have a case set for here? Did she bind her case over? I'm not sure.
No, I believe she's also charged with a misdemeanor fourth. I believe it's set for a jury trial, if I remember correctly.
Sorry, set for jury trial. Okay. And so I don't know who's going to be in custody and care of the child, but if the court is going to, or CPS, I should say, is ordering someone to have custody of the child, and then that person is contacting Mr. Smith in the middle of the night saying, "Come get your kid." I'm just trying to place myself in his position as a parent. I'm gonna go get my child.
And I'm not debating that, Your Honor, at all.
However, you have to protect yourself if something like that happens, and you gotta get your child, and probably, you probably should contact your attorney immediately, because at 3 o'clock in the morning, I'm sure the court's not available. You needed to have contacted someone for your own protection, because I don't think the order of the court was that you could not be around your child, but that you must be supervised is the only issue. I'm gonna credit him time served. We'll remind him of the no contact order. Again, there's an order that you're not to have contact unsupervised, and that will remain until your attorney brings us an order from the family court telling us otherwise. If there's an order from CPS, I don't care if it was from April 11th, that said that he was supposed to be the custodial parent, then we'll amend our order. Oh, I've not seen it.
Is the court willing to just remove the no contact provision without CPS? I'd like to remind the court, the issue here isn't Mr. Smith was a danger to the child. The issue here was the mother who had the physical and legal custody to the child, abandoned the child.
I don't know
Mr.
that.
Smith had nothing to do with that. Well,
That's
that's the
not the
government's,
alle-
that's the
That's not the
government's
allegations that
accusation.
I have in my affidavit of probable cause.
And
That-
it's charged based on the
My
some circumstances surrounding that, so. to
My
argue
understanding is that there was
facts
some evidence or some through text messages
here, Something.
that implicated him as to the responsibility on the date in question. So whether or not you want to have a hearing on that and bring some evidence before the court, because all I have is an affidavit of probable cause. I don't know what happened. I wasn't there. Prosecutor has all the information. You have all the information. Why would the court have all of that?
But I don't understand why are we being asked to have to come to court again and address an issue that I believe is unnecessary. There's no evidence that he posed.
So
a
everything you
danger
believe
to
is
the child.
unnecessary, we should just do it? Is that what you're saying?
Yeah.
Oh, okay. Well, I'm sure you've seen before that that's not how this works. We don't just do what Mr. Johnson believes is necessary. The court at the time of his arraignment believed it was necessary based on the circumstances that he not have unsupervised visitation. And this is a situation where there's a child abuse fourth and both parents are charged. The other parent has the same condition, I believe. I don't think there's been a violation. I've not seen her on a violation. If he's supposed to be the custodial parent, and again, I wasn't the one who arraigned him, but I don't see the bond condition as being inappropriate. I believe that the bond condition can be addressed if there is a family court order that says otherwise. Not because Mr. Johnson thinks it should be otherwise. That's why. And I understand, even as he's presented himself to this court since the pendency of this matter, that there is a concern about his level of responsibility. He doesn't get to court on time. He shows up like he just woke up. He don't show up at all.
Excuse me.
I didn't ask you to talk over me.
I came in 2 times.
I didn't ask you to talk over me. And so we have a child who is supposed to be his responsibility, and the allegation is that he wasn't being responsible. That's the allegation. Tell him to be responsible even as he presents himself in court. Get here on time and get here when you're supposed to be. I shouldn't have to tell you you're supposed to be here on time in person because your court order to appear said you were supposed to be here in person.
Excuse me.
I didn't ask you to speak. So the bond will remain as said until the time that there is a production of a CPS order or family court order otherwise that says that he's supposed to be the custodial parent of this child and have custody of him. Then they will change it. Until then, it's going to continue. Does your client have something you want to share with the court?
No, Your Honor, we just asked the court for a trial date.
Looks like he, let's see, this is a free trial. We can set it for trial. Give me a trial. Please. September 24th at 8. Is this the priority file? No. It's not the priority file. There's another case older than yours scheduled for that date as well, so this may get bumped.
Yeah, I had a felony trial in Ascota County that week.
Okay, we can switch it. Another date. It'll be October 1st. October 1st at 8. Any additional matters for today's record?
Not
No,
for
Your
people,
Honor.
thank you.
You're all set.